Hello and welcome to Module 7 of Real Estate Management. In this module, we shall be discussing property documentation and legal draft. That is securing ownership and preventing dispute through proper documentation. The module contents include importance of property documentation, draft of power of attorney, draft of tenancy agreement for apartment renters, draft of transfer of land or house ownership agreement, then key clauses in property agreement and legal implication of poor documentation before we draw our conclusion. Let us begin with the introduction. Why property documentation matters. 1. Property is a high value long-term asset. Legal certainty is crucial for ownership, investment, and financing. Oral agreements are insufficient. That is, written documentation is legally required. The objective of this model is to understand the importance of property documentation, learn key legal instruments used in property transaction, recognize the consequences of poor documentation, then gain familiarities with standard legal draft. Let us begin with the importance of property documentation. 1. It serves as a legal proof of ownership. Example like C of O, that is certificate of occupancy, and the deed of assignment. So property documentation give owner the right as a proof of legitimate ownership of the property. Number 2, protection against fraud. It prevents double sales as well as forged titles. Number 3, it facilitates transaction, which is essential for sale, lease, and mortgage. It also serves as an access to financing, which is required where collateral are required. Such document can be used for to obtain loan from bank in forms of collateral. Compliance with the legal law. It is a mandatory requirement according to the law that property documentation is necessary, such as Land Use Act, state regulation. So it serves as a compliance with legal laws. Number 6, it enhances property value. So clear title command premium price. Number 7, enforceability in the court of law. Yes, proper documentation are legally binding. Now let us look at the overview of property documentation. Number 1, certificate of occupancy, C of O. The purpose is primary evidence of government granted title. Then number 2 document is a deed of assignment, which is transfer of ownership from seller to buyer. Then governor's assent, which is mandatory approval for land transfer. Survey plan, which shows exact boundaries and measurement. Power of attorney, which authorizes someone to act on owner's behalf. Then tenancy agreement, which govern landlord-tenancy relationship. So these are some of the key property documents. Now let us look at the draft of power of attorney, POA. What is power of attorney? Power of attorney is a legal document where a principal authorizes an attorney to act on their behalf. Key uses in property include sales and purchase when owner is absent, property management, and registration process. Essential elements in power of attorney include the name and address of the parties involved, clear scope of authority, the property description, duration stroke validity of period, signatures, witness, and notarization. Legal effect. Acts within authority are binding. Abuse leads to liability. So it simply means that the attorney must act within the authority, whereby abuse may lead to liability to the what? To the attorney. Now let us look at a sample of power of attorney, the structure. The structure includes, look at the format of a power of attorney. This power of attorney is made these days. You write the day, is made the date of the day, you in the month of the so year by the donor, that is the principal. I appoint the donee, you put the name of the donee as my true and lawful attorney to do the following acts on my behalf: manage, sells, lease, or mortgage property at, you now put the address, sign deeds and agreement, apply for governor's consent and C of O, pay taxes and charges, appear before agencies or court, valid until revoked in writing, signed by the donor. The principal will now sign, and then the witness will sign. So this is a sample of power of attorney. Now let us look at the draft of tenancy agreement. Let us look at the purpose. The purpose is that it defines right and obligation of landlord and tenant for residential and commercial renters. Essential content in tenancy agreement include the party details, the property description, terms and commencement date, rent amount and payment terms, security deposit, maintenance responsibility, termination and notice period, as well as use restriction. Legal implication here is that both parties bound. Breach leads to eviction, damages, or legal action. So the tenancy agreement is binding on both parties. A breach may lead to eviction, damage, or a legal action. Now let us look at the key clauses in tenancy agreement. Number one is rent clause, which specify the amount, the due date, and mode of payment. Then number two is deposit, security deposit clause, which specified whether amount is refundable, deduction for damage, for if there is any deposit made. Then maintenance clause, tenant minor repair, landlord structural. So the maintenance clause must be there. Then quiet enjoyment, that is tenancy right to undisturbed possession. Then termination clause, which include notice period, example 1 to 3 months, as well as restriction clause, no illegal activities, no subletting without the consent of the landlord. So these are some of the clauses that could be found in tenancy agreement. So having known that, let us move further by looking into the draft of transfer of ownership, that is deed of assignment. What is it? It is a deed of assignment is a legal document transferring property rights from assigner to assignee, which is critical for sales, gift, or assignment of land and houses. It must include the following: full parties details, uh, recital of ownership, property description, that is survey plan and boundaries, purchase price and consideration amount, the covenant, that is warranty by the seller, the governor's consent clause must be there, execution and witness. So these are the content of deed of assignment. The legal effect is that transfer complete upon execution, registration, and governor's consent. Let us look at the key clauses in property agreement. Number one is party clause. This identifies the buyer, the seller, landlord, and tenant. So this clause identifies the parties that are involved. Number two clause is description of property clause, which give full details of the property involved, which prevent boundaries dispute. Number three is consideration clause, which specify the purchase price or rent details. Number four is transfer stroke assignment clause, that is the formal conveyance of right, so which specify the mode of transfer of property from one person to another. Then number five clause is governor's consent clause, which is mandatory for validity. Number six clause is the covenant, that is promised by parties. Example, the title warrant. So this clause must be there in property agreement. Then termination and default clause, which provide remedy for breach. Then dispute resolution clause, which specify how disputes are to be resolved, such as mediation, arbitration, and litigation. Then governing body. The governing body, usually Nigerian law. So this clause must be specified in a property agreement. Now let us look at legal implication of poor documentation. That is to say, when you fail to document properly the following abound. Number one, invalid and unforeseeable agreement. The court may void the document. So when there is a poor documentation, the court may not consider such agreement as legally binding. Then number two is that there is an increased fraud risk. So there may be double sell as well as forged document. Then number three, ownership dispute. There may be a dispute between one person or the other over the ownership of the property, which is costly, prolonged litigation. Then number four is loss of property right. Without governor's consent through registration, one may lose your right as the legitimate owner of the property. Then there is also a financial loss, which involves the property cannot be sold, mortgage, or recover investment. Then number six, the last, is succession problem, which is inheritance complication. So your children may not inherit such property. Now let us look at the best practice for property documentation. Number one, engage a lawyer for drafting, review, and compliance. Number two, verify all details such as names, property description, survey plan. Number three, obtain governor's consent and register, which is mandatory for transfer. Number four, stamp documentation, that is per Stamp Duties Act. Then number five, keep original safe. So keep original document in a safe environment, in a secure storage, such as digital backups. Then number six, the last, regular update is needed. Update record after any transaction. In conclusion, property documentation is non-negotiable for secure ownership. Power of attorney, tenancy agreement, and deeds of assignment are fundamental instruments. Clarity, completeness, and compliance prevent dispute and fraud. Poor documentation leads to legal vulnerability and financial loss. Always consult legal professionals for property transaction. Thank you for understanding, and God bless you.